A federal judge struck down core parts of the National Firearms Act just days ago, and the single most important question right now isn't what he ruled, it's what happens next, because this case is about to enter a phase that will actually determine whether this ruling means anything lasting at all. The Department of Justice has a clear path to appeal directly to the Fifth Circuit Court of Appeals, and given the significance of what Judge Hendricks decided, that appeal is essentially guaranteed. Most coverage of this ruling stopped at the district court decision itself, treating it as the headline and moving on, but a single district court opinion, no matter how well reasoned, is genuinely just the opening move in a process that could easily run for years before anything resembling a final nationwide answer emerges. I'm going to walk you through exactly what happens procedurally from here, what arguments the government is likely to make on appeal, how the Fifth Circuit has historically approached cases like this, and what it would actually take for this ruling to end up meaning something for gun owners well beyond the specific plaintiffs currently covered. Before we get into it, if you want to actually follow this case through its next phase instead of just moving on the moment the headline gets old, subscribe and turn on notifications right now. The appeal is where this story actually gets decided, and most coverage is going to move on to the next headline long before that happens, leaving you without the actual resolution unless you're specifically tracking it. Let's get into exactly what comes next. Here is the very short version of what's already happened, so the next phase makes sense. On August 5, 2026, Judge James Wesley Hendricks of the Northern District of Texas ruled that NFA registration requirements for suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons are unconstitutional because Congress reduced the tax underlying those requirements to $0 in 2025 legislation, eliminating the constitutional basis the Supreme Court originally relied on to uphold the registration system back in 1937. He stayed his own ruling for 7 days to let the government seek appellate relief, a stay period expiring around August 12th or 13th, and limited the injunction specifically to the plaintiffs in the case and their documented members and customers. The first segment is exactly what the Department of Justice is expected to argue on appeal, based on the legal terrain here. The government's strongest counter-argument likely centers on severability, the legal principle that even if part of a statute becomes unconstitutional, courts should try to preserve as much of the remaining law as possible rather than striking down the entire scheme if Congress's original intent can still be honored. The government could argue that Congress's clear intent, evidenced by the fact that the underlying deregulation language was only removed due to a procedural Byrd Rule technicality rather than any actual disagreement with fully deregulating these items, means courts should read the current $0 tax alongside the registration requirements as fully consistent with what Congress wanted, rather than treating the registration system as suddenly unconstitutional simply because a Senate procedural rule happened to strip out one specific piece of related language. The government may also argue more broadly that Congress retains authority to require registration and reporting for dangerous items, independent of any tax justification, pointing to other areas of federal law where registration requirements exist without being tied to active revenue collection, and could further argue that Sunzinski's reasoning was never meant to be read so literally that a temporary or even permanent reduction in tax revenue automatically voids decades of settled regulatory practice, especially where Congress never repealed the underlying statute or expressed a clear intent to eliminate the registration system itself. The second segment is how the Fifth Circuit has historically approached cases touching gun rights and federal regulatory authority, because this matters for predicting how receptive the panel might be. The Fifth Circuit, covering Texas, Louisiana, and Mississippi, has developed a reputation over the past several years as one of the more skeptical federal appellate courts when it comes to expansive federal regulatory authority generally, and has issued a number of significant rulings favoring gun rights challengers in cases working through its jurisdiction since the Supreme Court's 2022 Bruin decision. That reputation is exactly why litigators strategically brought this case in the Northern District of Texas in the first place, anticipating that if the district court ruled in their favor, an eventual Fifth Circuit panel would likely be more receptive to the underlying legal theory than many other circuits might be. That said, this specific case rests on a genuinely different, older body of taxing power precedent rather than the Second Amendment historical analog framework that's defined most recent Fifth Circuit gun rights rulings, meaning the court's general receptiveness to gun rights arguments doesn't automatically predict how it will handle this specific enumerated powers theory, which raises its own distinct legal questions the court hasn't directly addressed before. The third segment is the realistic timeline for how long this appeal process might actually take, because 7 days feels urgent, but a full appellate resolution operates on a very different clock. If the government seeks and obtains a stay from the Fifth Circuit while the appeal proceeds, meaning the injunction remains paused even for the covered plaintiffs while the case is fully briefed and argued, the existing NFA process would continue applying to everyone, including the plaintiffs, for the entire duration of the appeal, which could easily run many months given typical federal appellate timelines. If the Fifth Circuit declines to extend the stay, the district court's injunction would become operative for the covered plaintiffs while the underlying appeal continues in parallel, creating the somewhat unusual situation of a legal question being actively disputed on appeal while already partially in effect for a limited group of people. Full appellate review, including briefing, oral argument, and a written decision, typically takes many months at minimum in a case of this complexity, meaning even in the fastest realistic scenario, a final Fifth Circuit ruling likely isn't coming within weeks. The fourth segment is what happens if the Fifth Circuit affirms Judge Hendricks's ruling, because that outcome would raise its own new set of questions rather than simply ending the story. An affirmance would apply as binding precedent within the Fifth Circuit's jurisdiction, Texas, Louisiana, and Mississippi, but wouldn't automatically extend the same protection nationwide, since other federal circuits aren't bound by a Fifth Circuit ruling and could reach different conclusions if similar cases get filed elsewhere. This is exactly the kind of scenario that tends to produce what's called a circuit split, different appellate courts reaching different conclusions on the same underlying legal question, which historically is one of the strongest signals that pushes the Supreme Court to eventually step in and resolve the disagreement nationally. If you're wondering whether an affirmance would mean nationwide deregulation, the honest answer is not automatically and probably not quickly, since the broader national question would likely require either the Supreme Court eventually weighing in or Congress passing new legislation to resolve the underlying tax and registration mismatch directly. The fifth segment is what happens if the Fifth Circuit reverses instead, because that outcome has its own important consequence worth understanding. A reversal would mean the existing NFA registration process resumes applying fully to the current plaintiffs exactly as it does to everyone else, effectively undoing the practical protection this ruling currently provides. But remember, both sets of plaintiffs deliberately preserved their Second Amendment arguments by asking the district court not to reach them in the first place. A reversal on the enumerated powers question wouldn't necessarily end the case entirely. It could send the matter back to the district court specifically to address the Second Amendment arguments that were set aside, opening up an entirely separate legal battle over whether suppressors and short-barreled rifles are constitutionally protected arms under the Bruin historical framework, a fight that would then play out on its own extended timeline. The sixth segment is what other states and other litigants are likely doing right now in response to this ruling, because a significant district court decision like this one rarely stays contained to a single case. Attorneys and advocacy organizations in other jurisdictions are almost certainly reviewing this opinion closely to evaluate whether a similar enumerated powers argument tied to the same $0 tax provision could succeed in front of different judges in different circuits, potentially creating additional pressure toward the kind of circuit split that eventually forces Supreme Court review. Congress itself represents a separate, faster potential resolution path worth watching, since lawmakers could, in theory, pass new legislation explicitly and cleanly, removing suppressors, short-barreled rifles, and related items from NFA regulation entirely, resolving the current tax versus registration mismatch directly through legislation rather than leaving the question to years of continued litigation, though whether Congress has the political will and votes to do that in the current environment remains a genuinely open question. Let's step back and name what actually matters most about where this case goes from here. The August 5th ruling was a real significant legal development, but it was also just the opening move in what's likely to be a multi-year legal process involving an almost certain appeal, a realistic possibility of a circuit split, and potentially years more litigation before any truly nationwide permanent resolution emerges, whether that resolution comes from the Supreme Court, from Congress, or from some combination of both. Anyone treating this district court ruling as the final word on NFA regulation is getting ahead of a process that, by its own nature, moves in years, not weeks. It's worth sitting with just how common this exact pattern is in major constitutional litigation, because it applies far beyond this one case. A significant district court ruling generates the biggest headline and the most immediate public reaction, simply because it's the first concrete result in a legal fight that's often been building for years. But district court rulings get appealed constantly, and appellate courts reverse district courts often enough that treating any single trial-level decision as settled law is a genuinely risky assumption, regardless of how well-reasoned the underlying opinion is or how sympathetic the judge's reasoning might sound. The real, lasting answer to a question like whether the NFA's registration scheme can survive a $0 tax almost certainly won't arrive until this case, or one very much like it, reaches a final resolution at the circuit court level at minimum, and quite possibly not until the Supreme Court itself weighs in, a process that historically takes years rather than the days or weeks that headline cycles tend to suggest. If you take one thing away from this breakdown, let it be this. A single district court ruling, however significant, is rarely ever the end of a major constitutional fight, and understanding the realistic appellate timeline ahead is what separates genuinely following this story from getting swept up in a headline that promises more finality than the legal process actually delivers. Watch for the Fifth Circuit's response to the stay request first, since that alone will tell you a great deal about how the appellate court is initially leaning, well before the full merits appeal is ever briefed and argued. If this helped you understand what actually comes next, instead of assuming the fight is already over, share it with someone who thinks this ruling is the final word. Subscribe so you catch every step of the Fifth Circuit appeal as it actually happens, and I will see you in the next one.